Well, folks, this is document 253 that has been filed in Colborn versus Netflix. Declaration of Kevin L. Vick under penalty of perjury and subject to U.S. statutes declare as follows. I am one of the attorneys for defendants Laura Riccardi, Mordimos, Crow Media, collectively the producer defendants, and above caption action. I have personal knowledge of the matters set forth in this declaration. I make this declaration in support of defendant's joint civil LR7H expedited non-dispositive motion and for order allowing defendants to depose plaintiff for 14 hours collectively. The expedited non-dispositive motion. Attached is Exhibit 1, a true and correct copy of pertinent portions of the transcript of the deposition of non-party Brenda Schuler, including all following excerpts. Pages 166, 167 and 67 of the deposition transcript contain testimony regarding plaintiff forwarding Ms. Schuler his communications with attorney Michael Griesbach during his representation for his litigation. B. Pages 283, 286 of the deposition transcript containing testimony regarding paper, documents, and discs containing evidence that plaintiff provided to Ms. Schuler. Page 309 through 311 of the deposition transcript containing testimony regarding Ms. Schuler contributing edits to the complaint on the non-considering whether attorney-client privilege was an issue. Pages 316 through 318. Deposition transcript contained testimony regarding Ms. Schuler's concerns about getting her stuff to be privileged when she was assisting with the litigation on a volunteer basis, but not as a paid employee. Page 318 to 321 of the deposition transcript contained testimony regarding conversations between plaintiff and Ms. Schuler regarding her not having an official role on the legal team, but confirming her continued involvement in the role of drafting an initial complaint. And pages 341 through 348, deposition and the transcript contained testimony regarding, I have no idea. Counsel for all parties conferred, but were unable to come to an agreement regarding a number of hours to depose plaintiff Andrew Colborn. Attached to Exhibit 2 is a true and correct copy of the meet and confer email correspondence regarding plaintiff's deposition. In addition, during a conference call between counsel for all parties held on June 16, 2022, counsel for producer defendant explained that defendants would soon file an expedited non-dispositive motion with the court in the light of the parties' inability to informally resolve the issue of the appropriate length of Ms. Colborn's deposition. I declare under penalty of perjury foregoing true and correct, dated June 24, 2022. Exhibit 1, the matter of Andrew Colborn on Netflix, Brenda Schuler, May 20th, 22, confidential, Colleen Reed Reporting, LLC, United States District Attorney, Eastern District of Wisconsin, Andrew Colborn, date May 20th, 2022, from 8:39 to 4:57. Location Godfrey Con, S. East Michigan Street, Suite 1800. Reported by Janet D. Larson. Appearances: Scott Bullets, Engel by April Roxy Baker, Ballard Spar, Jesse, Vick, Caroline. I'm not going to read all these names. Confidential. Also present via Zoom, video conference, Maura Demos and Laura Riccardi. Do you see all that? Answer: I do. Do you remember getting an email from Mr. Colborn in reference to what he says here about Judge Pamela Pepper? My recollection isn't great on it, but I believe it was something regarding like her history on a website or something. Did you get the email? I don't remember exactly what it was. Question: are you willing to run a search for the name Pamela Pepper and send us the email you have about her? Possibly. And Mr. Colborn says, I will forward what Mike sent me about her. Did you see that? Yes. And so he's forwarding you a communication that he had with Mr. Griesbach. I withdraw that. My first question is Mike a reference to Mike Griesbach? Correct? Yes. Ms. Baker, object as to foundation. Question. So he was forwarding a privileged communication he had with his attorney. Mr. Griesbach, correct? Ms. Baker, same objection. Answer. I don't know. I don't know how privilege works. I'm sorry. I don't know if was just sharing something he didn't care if it was privileged or not, or if all attorney-client is privileged for anything. I don't know. But yes, he forwarded an email from Mike Griesbach. Okay. And he said, just between you and me, though. And what was your understanding of what he said that? Ms. Baker, objection and foundation. Answer, not to share with anyone? Question, did he ever tell you to not tell Mr. Griesbach that he was sharing communications with you? Maybe. I can't think of anything offhand, but maybe. He could have said, don't share this with Mike. I don't know. Exhibit 228, marked for identification. The court reporter just handed you Exhibit 2028. Again, there are text messages between you and Mr. Colborn, correct? Yes. And the exhibit begins at Bates number 8990, but I'll direct you to the 3 pages in 8992. How much they support our decision to this, and the pastor told me we will all be in his prayers. Thought you would like to know that, Brenda. Did I read that correctly? Answer, yes. And you say, aw, thanks so much. That is wonderful to hear. And he says, you betcha. Nice to have the support of a church, and people seem to be happy about what we are doing. Did I read that correctly? Yes. And so, like he had the support of his law enforcement community, Mr. Colborn had the support of his church community, correct? Yes, his church, yes. Oh, you can hang on to that, actually. Okay. For just one more minute, I'll take that back. I'm going to hand you another exhibit, Exhibit 2051, marked for identification. So the court reporter has handed you Exhibit 2051. These are text, and really they're text with some photographers from Mr. Colborn to you, correct? Or photographs. Correct, yes. And at the top of the Bates number 5126, he says, this is what I have for you. And he sends you a picture of a box with some files in it. It looks like, is that correct? Answer, correct, yes. Question, and this was coming in June of 2018? Right. Yes. And what was in that box? That was the file that he had previously given to the prior attorney that he had gave to me. It was the CDs that we were talking about earlier, the 27, his personal report. That's 27, that's phone calls. Oh, his personal, and it was everything pretty much from Manitowoc County regarding his personal report. Complaints he had received, or did not want to say complaints, emails he had received that we talked about earlier. What else was in there? It was everything related to him personally that he had given to prior attorney that he had hoped would take his case. Do you know the attorney's name? No. And he or she decided not to take Mr. Colborn's case. Well, whoever that attorney was fucking smart. I don't know if the situation, honestly, I don't know what it was. He never talked to you about why that attorney said no. Maybe. I don't remember what he said about it. I just knew that he wasn't taking it. Whoever it was. Well, it's a female, for one. We know that now. Might have been a prior. I thought she worked for. He knew her through his job somehow. Which job? That's the question. Have you given us documents in that box in the picture? That's the ones we talked about earlier with all of the complaints and the personal reports. So all the 10. Yes. It's a pretty small box. Does seeing it again make you more willing to give us everything? Answer: I think everything in it you're either going to either have or it's that 10 complaints because that is what was given to his lawyers. I don't have this box anymore, so it's I did give you the personal report, I believe. So you don't have this box anymore. No, nor this. Okay. But you think you gave us everything. Did you make a copy of everything that was in the box before you gave it to his lawyers? I scanned a lot of it, and I also had the WAV files of the CDs with the calls. Okay, so you think you have given all of it to us. Everything that I have copied or put online, yes. Okay, on the next page there's another photo of a file in the plastic folder. Do you see that? Yes. And what was that? I just wanted to see what this one is, since released of Making a Murder. Okay. These are formal incident reports. The top one anyway, incident reports that came in. Whether it be like the bomb threats that they received. He had a couple of interactions with people threatening him. So there were more of the incident reports. I know there was a lot of emails between one of the two parties that just went back and forth, and I believe there are several copies of the same one that seemed like a big stack, because I remember kind of sorting it. The CD is right. Which phone call again? Say it again for me. Sure, the 9596 phone call that Andy received and transferred. Got it. So they have that phone call? Interesting. To a detective, yeah. Mike was under the impression, I believe somehow, some way, that Couchet actually received a call, and I caught that in the complaint and said, I never heard that. Where is that from? Question: Mike was under the impression because Couchet might have told him that. Answer: no, I don't know how Mike was under the impression. I have no idea. Just a mistake? Answer: right. Question: we'll move on. I'm going to hand you exhibits at once. There'll be 2063, this will be 2064, and exhibits 2063 and 2064 marked for identification. Alright, if you could look at 263 first, this is an email Mr. Colborn sent to you on December 7th, 2018. Yes. And it forwards an email he got from his attorney, Mr. Griesbach, correct? Correct. And it's partial draft of the complaint about a week before it was filed, correct? Correct. And this is when we've seen the text messages between you and Mr. Colborn about your edits, but this is the email where he actually sent the thing to you, correct? That's what it looks like, yes. And Exhibit 264 is a similar email where Mr. Griesbach has sent the second section of the complaint, draft complaint, to Mr. Colborn, and then Colborn sent it to you, correct? Right. The second part, correct. And do you have any concerns at all, as all this was happening, about Mr. Colborn preserving attorney-client privilege? No, because I wasn't aware of any of that. I even was working with Mike researching in the book. I felt like things that a legal assistant would almost do. So no, I didn't even know that. To be honest, that would be an issue. I didn't even think about it because Mike did know I was checking it. I didn't remember that Andy sent it to me first. So at some point, Mr. Griesbach found it. He maybe didn't know on December 7th, correct? Very soon after? Question. Okay. Let's mark this exhibit 2065, and I'll give you just a minute or two to review 2065, as I'm going to pointing you to, I'll give you a chance to review it, but then I just want to confirm that these are the text messages between you and Andy Colborn talking about edits to the complaint. Exhibit 2065 marked for the identification. Alright, let me take a look here. How far do you want me to read? I'm sorry. Well, let me ask you this. This was all sent on December 16, 2018, correct? December 16, 2018? Answer: correct. And this is just a couple days before the complaint was filed, correct? I believe one day, or 2 days, yes. And you're in this text message chain going back between you and Mr. Colborn, correct? Yes. And you'll direct you to page Bates number 7072, okay? We do not have to read this. This is a big, long text. I know. Who is this? Him to me to him, you to Mr. Colborn. Let me read the first couple lines, okay? And just to set the stage, this is January 6, 2019, right after the complaint was filed, correct? Correct. So you say, Mike is on the other line with him now. He called while I was chatting with him. I'm glad he did because of the attorney work product. I'm not, quote, officially working, quote, for Mike. I'll have to ask him how we get my stuff to be privileged. Anyway, period. And then you go on to talk about this character named Rocky Lopomarto. I'm going to have to look that name up. But my question is, it seems maybe to have concerned you to, at this point, there are privileged attorney work product issues. Yes. And you were expressing, I don't know if it's concern or maybe curiosity about that. Right after, yes, that's what it appears, definitely. And did you ever ask Mike, quote, how we get my stuff to be privileged, as you say there's in the text message? My recollection, I don't know if this, when this was, but yes, I remember sharing information again up until April, and then the group took over, just saying how I don't want my things to be public, okay? I don't think I necessarily was thinking about anything about his stuff not being privileged by including me. I was more worried about my stuff becoming public that I was sharing with him. Okay, and did you ever get an answer from Mr. Griesbach about that? If I recall correctly, I believe he said just put attorney-client privilege on it or something because I was not officially in paid capacity working for him. More of, I don't know what I was, a volunteer? I wasn't officially working for him, but I was certainly helping him. Got it. Ms. Walker, let's mark this as 2069. Exhibit 2069 marked for identification. 2069 is another text exchange between you and Mr. Colborn, correct? Yes? Mm-hmm. And this is now a couple of months after the lawsuit was filed on February 8th of 2019. Do you see that? February? Yes, I do. And you say to Mr. Colborn, hey, are you around? He says, yeah, I'm at home. What's up? And you say, oh, no biggie. Mike left a message about the meeting and sounds like I can help. I can't help at all. Do you see that? Yes. And you say I don't want to be deposed, but I said if they wanted me to sign something that I can help with no pay, I'd be happy to, but they don't think it's a good idea. It's all good. Was just going to fill you in if Mike hadn't yet. Do you see that? Yes. And tell me about the message you left or the conversation you had about why you were no longer able to help with the case. Sure. As you can probably tell, prior to the complaint being filed, I was a big part of helping the research aspect of it. I think that was also always kind of the plan. I wasn't doing much with transition at that point, if hardly anything. So when April and the group came on and took it on, they obviously had their own resources. I wasn't an employee of Mike's. Officially, I couldn't really bring any value to them. I had hoped I could because I wanted to be part of that. And it just wasn't it. I wasn't able to do that. And for obvious reasons, they have their own staff. I'm not an attorney, so he was just letting me know that I really couldn't know anything, be a part of anything, see anything. So it was kind of, I think, where the big cutoff was, where I handed off and had to step back quite a bit. Mr. Colborn seems fairly disappointed by that. He says in the next text message, Mike hadn't mentioned that. I was really hoping you could be involved, although I certainly see why they wouldn't want to be deposed. Can you still give info to Deborah, and will you still be willing to do you see that? I do, yes. And in fact, what happened that Mr. Colborn didn't continue to keep you in the loop on this lawsuit off and on, correct? Objection, foundation. I think not to the same degree as I stayed with him, obviously, but yeah, I mean, he told me periodic things too, sure, more as a friend than a resource person. The info or reference giving to Deborah, yes. What was that? And did you give it to her? I did, and I did include those in discovery. I was handing off all my research documents that I felt would be applicable in the complaint that I had used to check the complaint. So I was basically just getting her up to speed on the background of the case. The investigator, did you have a conversation with her? I did, yes. To orient, I met with her. You did, yes. Okay, did you ever draft any exhibit to any complaint, like a comparison, a list of defamatory statements, or a comparison of trial testimony to what was in Making a Murder? In the first complaint, yes, I did. The second complaint, unless they used something from first complaint, I had nothing to do with the second one. And again, I don't know what you call it, amended complaint. When April and George came on, the first one, yes, I know I had exhibit in there. Miss Walker, marked as Exhibit 2070, marked for identification. So this is an email string with a lot of signature block, right? Stuff we can ignore at the end, but if you flip backwards from that, the first real email at the bottom of the chain is from Deb Risick to you, asking if there's a piece of paper regarding the dispatch call Mr. Colborn received. Do you see that on January 16, 2019? What page are you on? I'm on 2829. Of course, it's redacted. Wonderful. Confidential, Reddit sheet, opponent, Brenda Schuler, date 5/2022, case Andrew Colborn, Netflix, page 14, line change, paste to contractor, clarification, my error, reporter error, my error, reporter error. I regard to 17 above the question by Miss Walker, who had taken out of context. She did not reference that my text, "We should shoot all liberal law professors," was a response to an attached article lifted something to the effect of the U.S. professor thinks all cops should be killed. Okay. Signature page, Brenda Schuler, hereby certified I have read the foregoing transcript proceedings taken on the 20th day of May 2022, same true, correct. I'm going to contact this Colleen Read and Reporting LLC and see if I can get my hands on this deposition. Confidential, State of Wisconsin, Janet D. Larson, Notary Public, and for the State of Wisconsin, do hereby certify the deposition of Brenda Schuler was taken before under pursuant to Federal Rules of Civil Procedure 20th day. That before the witness testified, the first release point to testify the truth. I am not a relative or employee of the attorney counsel of any of the parties, or a relative employee of such attorney or counsel that is financially interested directly and indirectly in the action. The foregoing pages are true and correct. Transcript of the original shorthand notes taken at the time and place. Exhibit 2. We got these emails. George, while I appreciate you responding, we cannot accept your proposal as it would leave things uncertain, risk delaying the case, jeopardize our client's ability to fairly defend themselves against Mr. Colborn's lawsuit. Mr. Colborn has chosen to sue numerous defendants, and the defendants are entitled to responsible opportunity to depose Mr. Colborn, which would take a sufficient amount of time given the scope of the issues in the case explained in the prior emails. Moreover, a particular matter in order prepared Mr. Colborn's deposition, defendants need to know in advance that they will have sufficient time to question Mr. Colborn. We cannot leave things entirely in the hands of Mr. Colborn's counsel to utterly decide whether defendants receive additional time before 7 hours, nor would we want to complicate the existing case schedule by having to initiate motion practice in August if the disagreement as the appropriate amount of time across Mr. Colborn's deposition on July 28th. As a result, we intend to file a motion with Judge Ludwig and will request an order permitting defendants 14 hours collectively to depose Mr. Colborn. Another email. Kevin, thank you for the response. Apologize slight delay responding as I was focused on briefing the dispositive motion in another case. We continue to disagree over the need of additional time and question Mr. Colborn. Regardless of the 14 hours, question is extravagant. I have a few thoughts of the possible compromise. First, you list 8 areas of substantive questioning, but 3 involve areas which Colborn would have no meaningful information about. He has no personal insight into the defendant's actual malice or intentions to harm him. I very much doubt the court would permit his opinions about another state's mind without subject at trial. So too those statements other people, including Mr. Avery's lawyers, made at trial. Those can be confirmed in the transcript and film, and Colborn did not attend large parts of the trial. Questioning on these subjects should therefore be short. Second, you refer to complaint as a length of complexity, but the complaint was drafted by lawyers, and like many other witnesses, Colborn is a witness who can testify only about facts that he knows. He will not know facts pertinent to the Avery aspect of the complaint. Other witnesses furnishes that the information. You are certainly free to question as you see fit, but going through a voluminous complaint may not yield information you seek. Third, you mentioned that the length of the interrogatory answers and the volume of the documents produced in discovery. We respond in the length because many questions called for narratives, thus we provide them. Some questions were the type usually seen in depositions, so I would hope any lengthy answers would inform or perhaps shorten rather than lengthen questioning. As for documents, most have no relevance, and we too dealt with the large volume of documents you and Lita produced, but still kept within the rule. Fourth, both April and I adhered to the 7-hour rule in the questioning. We did so even as several witnesses often gave lengthy, seemingly rehearsed, non-responsive answers to pointed and direct questions. We had a choice to make under the rule: dwell on the question, spend valuable time debating with the witness with no certain hope of getting a direct answer, or more on the ensure that all topics we planned to cover were covered in questioning. We often choose the latter for the sake of the time. I doubt you will encounter a similar problem with Colborn, who, in my experience, speaks directly and straightforward. However, the same rule should apply to both parties. Fifth, you mentioned the sued multiple defendants, yet this case has been pending for about 2 years, and defendants have presented a joint and unified front. I recall no cross claims, and I would be surprised if a joint defense agreement did not exist between them. 6, you already have benefit of previous trial and deposition testimony from Colborn, so that again would abbreviate the questioning. There are other points to make that should be enough to explain our view. However, I have a possible compromise. We both must forecast about questions and answers we have not heard, a task which makes predicting whether 7 hours per questioning will be adequate to learn the critical facts that Mr. Colborn knows about difficult. I suggest we just keep both dates on the calendar, because the question is efficient and non-duplicative, and promise I will permit questioning beyond 7 hours, because I understand Judge Ludwig will allow you enough time to discover what Mr. Colborn knows. On the other hand, perhaps the questioning is completed in a lot of time and the whole issue becomes academic. There are 3 added advantages. We will have a better idea about what we are dealing with, and questioning begins, and will not need to presently trouble Judge Ludwig with the same uncertain situation we now face. We are to disagree July 27th and need to further time to the option to bring motion. Subject remains. Please consider advice. Thanks, GB. You mentioned exploring waiver attorney-client privilege. As I think I mentioned some time ago in a meet in conference, I think the privilege is waived to an extent that Colborn revealed otherwise privileged communications to third parties by communications not revealed remain privileged. Let me know if you have Lita agree, as we should get this worked out before testimony so as to avoid, if possible, instructing the witness to not answer questions in further motion practice. Further question, I'll note that Mr. Colborn's offer of the Second Amendment complaint in 56 pages long and relates to the events occurring over the course of more than 2 decades. As a bare minimum, we need to address the deposition elements and claims a certain related issues, including the range of allegedly material false statements on which Colborn's Second Amendment complaint is premised, underlying facts related to such statements, the extent to which statements were made by Stephen Avery's attorneys as his trial for the murder of Teresa Halbach and were widely reported to the media prior to making a murder. But I don't think I don't think anybody realizes that this whole trial was broadcast on the internet by all the news stations. They had their cameras in the courtroom, and it was being live streamed on the television and on the internet, on their websites. Actual malice of Mr. Colborn's contentions regarding same, the full scope of damages that Mr. Colborn claims he has suffered, including e.g. perpetual damages, emotional distress, etc., approximate causation of such claimed damages, alleged intent to cause emotional distress, Mr. Colborn efforts to mitigate and claim damages, including an interplay of any such efforts, Mr. Colborn, and his involvement in the convicting documentary project. Besides those obvious subjects, Mr. Colburn's deposition also will need to address certain subjects that have recently come to light in discovery, including violations of rules surrounding the confidentiality mediation held before Magistrate Judge Duffin last year, and extent of certain waivers of attorney-client privileges by Mr. Colborn. Moreover, Mr. Colborn's original and supplemental responses to my client's interrogatories total approximately 70 pages, and also have served 15 pages responsive to the Netflix separate interrogatories. In addition, Mr. Colborn has produced significant numbers of documents in this case, and additional relevant documents have been obtained third parties such as Manitowoc County, Calumet County Sheriff's Department, in response to the parties' various document subpoenas. Mr. Colborn has also denied virtually every request for admission that was served on him in this case. In sum, there's a lot to ask Mr. Colborn about, and unlike the situation with defendants where plaintiff took 4 party and party-affiliated depositions, there are not multiple people on plaintiff's side to depose, just Mr. Colborn. We also anticipate showing Mr. Colborn various video clips during his deposition, as the depositions of prior witnesses made clear that can take time. Indeed, the deposition of non-party Brenda Schuler took nearly 7 hours. Despite counsel's efforts to be efficient and non-duplicative, Ms. Schuler obviously had less information than Mr. Colborn. It did not plan to replicate the questioning covered by Netflix counsel, and I presume that Netflix counsel does not either. But I do anticipate that we have to follow up questions to certain lines of questioning from Netflix counsel and vice versa. And I anticipate that we will have lines of questioning that Netflix will not get into, and vice versa. While Netflix counsel and I will, of course, do our best to officiate the avoid unnecessary replication, I do not see how Mr. Colborn's deposition questioning could be adequately covered in just 7 hours. This is practically true, given Mr. Colborn had claimed in his discovery that he entitled to many millions of dollars in damages from my clients individually who had entitled to fair opportunity to defend themselves accordingly. Therefore, we are requesting that Netflix, on the one hand, Laura Riccardi, More Demos, and Chrome Media, on the other hand, each be given 1 day or 14 hours total collectively for all defendants to depose Mr. Colborn, although we will do our best to proceed expensively and will not use time gratuitously. There is responsible given to the scope of Mr. Colborn's claims and the underlying events, the amount of material that needs to be covered in his deposition, and the size of the personal liability Mr. Colborn seeks to impose upon my clients. Kimberly Clark, Worldwide, First Quality Babe Productions, noting the FRC Approval 30 provides a 7-hour limit only presumptive, and the court must allow additional time consistent with Rule 26B to, if needed, to fairly examine the deponent. Please let us know if you agree to our request or whether we need to seek relief from court. Sincerely, Kevin. Kevin L. Vick, another email. In response to your question, as we indicated to the defendants, we would collectively need more than 7 hours to depose Mr. Colborn. Mr. Colborn chose to bring a multi-party lawsuit suing Netflix, Pro Media, Lord Ricardi, and Demos, and Mr. Colborn seeks to impose liability against, recover significant damages from each and every one of them. Accordingly, the various defendants and their respective counsel entitled to sufficient time to depose Mr. Colborn to fairly defend Mr. Colborn's claims. Mr. Colborn filed a lengthy and detailed Second Amendment complaint with exhibits alleging claims, defamation, infliction of emotional distress, and covering events beginning back in the mid-1990s. Defendants are entitled to question Mr. Colborn about the substance of the allegations and elements of his claims, including, by way of example, the facts underlying the allegations he claimed damages. Mr. Colborn also produced documents, served response to the interrogatories that further required detailed questioning at this deposition. Finally, it should be noted that in addition to disturbing, voluminous, burdensome written discovery, and all defendants, Mr. Colborn himself took the depositions of four-party or party-affiliated witnesses, Ms. Nishimura and Mr. Del Deo from Netflix, plus Ms. Demos and Ricardi. By contrast, defendants are only requesting sufficient time to depose Mr. Colborn to ensure that they receive fair opportunity to prepare their defenses to Mr. Colborn's lawsuit. Please let us know. You will be agreed to this request, Kevin. And that's the last of it. It's a shame that all that was redacted. How many pages was it? 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 pages redacted. But I am going to contact this Colin Reed Reporting LLC in the morning and see what I can get, because if I can get this deposition or more of them, I'm definitely going to. But y'all got any questions before I disappear? No, apparently he's only asking for $10 million now, because they're only using season 1. Because I don't think there's anything in season 2, to be honest. Because season 2 is basically just focused on Brennan being released, and then the 7th Circuit denying his release, and then all the testing that Zellner was doing. I recently watched Mem AM 2 for the second time. I watched about 3 episodes, I think, about that, and then I fell asleep. I've only watched each documentary season one time. First time it came out, both in 2015 and 2018. But y'all have a good one.